Hi friends, welcome to this live broadcast at the Dispatch. You might have seen that over past couple of days, a number of senior journalists in the media fraternity of Delhi and elsewhere in the country have been speaking in praise of a recent order of the Supreme Court of India, which makes a reference to a 1962 judgment in case of Kedar Nath Singh. A number of journalists have written or spoken about in praise of the Supreme Court judgment, particularly the Editors Guild of India, that's comprised of the veterans of the media fraternity in the country. They have also issued a written statement in praise of the Supreme Court of India's judgment. So what is the judgment? What's the latest case in point? And what is Kedar Nath Singh judgment of 1962 that relates or impacts the working of the media fraternity so much, and what's its relevance here in 2021? Basically, this case pertains to the sedition because a lot of journalists have been finding themselves being vulnerable to being booked under the sedition law. So that could challenge the quality of democracy in the country, because if journalists fear being booked under the sedition law, not many of them will then challenge the policies and action of the government. If policies and actions of the government are not questioned adequately, particularly in interests of the public, so that might allow the government a complete whatever the government might want to do, so not being questioned, so that could significantly challenge the quality of democracy. The latest case in point relates to a senior journalist, Vinod Dua. He does these video programs, video blogs on different Facebook channels. Earlier he used to do that at The Wire, but for the past some time he has been doing these video blogs on the HW News. So Vinod Dua did one of the in one of the video blogs which Vinod Dua did. He criticized the government's policies and actions, particularly in handling of the COVID-19 pandemic. Vinod Dua said that Vinod Dua felt that there was an abject failure of the government, that it could not do enough to protect people or to assist people in the COVID pandemic, particularly with relation to the sufferings of the working class and the migrant laborers, etc. He also said that this could lead to the scarcity of food, and which could trigger to the food riots. Reacting to this, BJP worker in the state of Himachal Pradesh moved to the police and filed a sedition case against Vinod Dua. And he said that in his case, he said that Dua's assertions, Dua's opinion, and Dua's commentary on the handling of COVID pandemic by the government has the potential to cause disaffection against the government, a government established by the law. So Dua went to the Supreme Court seeking quashment of the FIR against him. But the Himachal Pradesh government also went to the Supreme Court, and Centre also went to the Supreme Court defending FIR against Dua. And Himachal Pradesh took the matter so seriously that it was represented in the Supreme Court by top lawyer, top attorney of the government, Mr. Tushar Mehta. The government said in the Supreme Court that this amounts to causing disaffection against the government established by law, and that could be a potential trigger for a disorder in the society. The Supreme Court examined the matter, and Supreme Court said that the government and the state and the present people who occupy the positions of power have to be dealt with separately. The Supreme Court said that it's fine to criticize the actions and the policies of the government, and there has to be a fair balance, in understanding the freedom of expression, and the freedom of expression has to be seen in the context, the freedom of speech has to be seen in the context that you're free to criticize the policies of the government as long as you are making a comment but that's not leading to any kind of violence, that you are not triggering any kind of violence. So there has to be a fair potential line of separation between what you say in criticism of the government, but that is not accompanied by any actions that could actually stabilize the government, that could cause violence, or that is a clear cut call to the violence. So Duwa's petition had also a very important component. While one is very happy to note that the Supreme Court made a reference to the Kedar Nath Singh judgment of 1962 and said that, no sedition case is made out against the journalist while for his actions of criticizing the government. So the journalist is fairly within his roles and responsibilities to criticize the government. So there is nothing wrong about that. So this does not make out a case of sedition under the Indian Penal Code. Now, there was a very important other plea made by Dua in the Supreme Court. He said that a rule should be made, the Supreme Court should intervene and ask the states to make a rule that all those journalists who have a standing of at least 10 years as uninterrupted journalists for 10 years should not be booked under sedition law. If there is a case made out against them, if there is a feeling somewhere that a particular story or a particular reportage of the journalist amounts to sedition law or has the potential of causing violence or challenging the actions and policies of a state, a government established by law, that should be referred to a committee for clearance. If that committee clears that yes, this amounts to petition, this amounts to sedition, it should be in only that case that you file a sedition law against the government. So the petition, submission of Mr. Vinod Dua, senior journalist in the Supreme Court, was that there should be a committee which should comprise a judge of the High Court and several other people. The government should refer such a petition, such a complaint to that committee. If committee clears, if that committee says that yes, this amounts to sedition, it's only in that case that that the authorities should book a journalist under sedition law. So that was to seek an adequate protection and also make sure that journalists are not unnecessarily harassed just on the basis of differences of opinion or perception. And such things have already happened in case of domestic violence or in case of doctors, because if something happens in the hospitals, so doctors have an adequate protection that they are not immediately booked if someone goes to the police or the judiciary. But the Supreme Court has so far refused to, Supreme Court appreciates, but has so far refused to intervene into that, because Supreme Court said that this should be a matter of the legislature. This should be a domain of the legislature to look at it, that whether there is a requirement or it's a law-making authority that they can define that what should be the approach of the state when a journalist is accused of sedition. So it's a matter of great significance and importance that has created a good debate across the country, that if journalists criticize the actions and the policies of the government, so there should not be a complete a culture of going to the police or the judiciary to seek action against them. So thank you very much for watching today's broadcast.